Good evening and welcome once again to another program of Issues in the News, where we discuss the important events that would have taken place in Guyana over the past week or so. And as usual, we always have a packed program of relevant and important issues to discuss and discourse. Tonight is no different. I want to begin by welcoming our viewers who are joining us uh, on television in region number 5, Mahaika, West Coast, Berbice. Welcome once again to another program of Issues in the News. To our viewers who are joining us in region 6, East Berbice, and along the Quarantine Coast, good evening and welcome once again to another program of Issues in the News. To our listeners who are joining us on Freedom Radio from Rob Street, Georgetown, good evening. Welcome to another program of Issues in the News. And last but not least, to the hundreds, if not thousands of you who are joining us on Facebook Live across Guyana, the Caribbean, North America, Europe, and further afield, welcome to another program of Issues in the News. And I see we have already a large number of persons joining us here. Omar Sharif, Sesnarain Samaru, Rakesh Pare, Mike, Janvi Pandey, Josh Singh, Stella Joseph, Andrew Simmons, and so many of you. Welcome once again to another program of Issues in the News. And making the news tonight is a ruling of the Guyana Court of Appeal in which the Guyana Court of Appeal dismissed an appeal filed by Vikash Ramkisoon and Sarah Brown, who were appointed parliamentary secretaries on the PPP to represent the PPP in the National Assembly. You would recall that a challenge was made to their appointment on the ground that they were on the list of candidates for the PPP Civic at the 2020 elections. The case was dismissed in the High Court and we filed an appeal. And the appeal court also to this afternoon dismissed the appeal filed by us. I wasn't in court. I didn't get an opportunity to examine the decision, but we will be appealing to the Caribbean Court of Justice. We will be appealing to the Caribbean Court of Justice because I believe that it is imperative that we clarify this area of the law, and it's an important constitutional issue. The Court of Appeal has ruled against us, as the Court of Appeal has done on many occasions, and we have appealed on those occasions to the Caribbean Court of Justice, and the Caribbean Court of Justice reversed the Court of Appeal. Again, we will appeal the Court of Appeal decision to the Caribbean Court of Justice, and we hope that the Caribbean Court of Justice will settle the law on this very crucial constitutional question. So I'll say no more on that matter. I'll leave the matter there, and let us see how the Caribbean Court of Justice determines the issue. My attention was drawn to a victory rally which was held on Sunday the 16th of July by the opposition, a Partnership for National Unity, in Georgetown, I believe in the vicinity of Stabroek Market. This victory rally, I suppose, was to celebrate a victory at the last local government elections. And here is where you get the clear impression that there are different realities being lived by different people in Guyana. In the same way that the APNU AFC continues to say that they have won the 2020 general and regional elections, although the entire world knows and saw differently, and notwithstanding the fact that they have been unable to produce evidence of that victory, which evidence they have in their possession, that is to say, the statements of poll, they proclaim and continues to proclaim victory at the 2020 elections. In similar vein, in the 2023 local government elections, they continue to proclaim victory when the results of the elections say otherwise, when the country knows otherwise, yet at a public meeting, which they were brave enough to televise and stream live on Facebook, the leader of the opposition mounts the platform and announced, and these are his exact words, the reality of the last local government election is that APNU by itself got more votes than the People's Progressive Party. And when you hear these statements and you live in Guyana and you participated in those elections and you are aware of the official results, then you have to convince yourself that either there is a large number of delusional people or there are alternative realities in the country. If you go and check the results now, you will see that the People's Progressive Party won 65 out of 80 local authority areas in which those elections were contested. 65 out of 80, the People's Progressive Party won. If you calculate that, you will see that it is over 80% of the elections held in the 80 local authority areas, the PPP won. Yet, Mr. Aubrey Norton keeps a victory rally and announces at that victory rally that APNU got more votes than the PPP at those elections. I am not making this up. This was not carried in the mainstream media because I suppose it is so ludicrous that the mainstream media decided not to cover it. But go on APNU AFC leaders' Facebook pages and go on the party Facebook page and you will hear and see Mr. Norton boasting to a crowd that APNU got more votes than PPP at those elections. And the people to whom he was speaking were cheering him or they were very vociferous. I don't know whether they were laughing at him. I don't know whether they were mocking him or I don't know whether they were congratulating him. But I heard a loud emanation of noise when he made that statement that APNU got more votes than the PPP. And when I heard that, I made some quick notes. Just in the municipalities, just in the municipalities, I recall that at Bartica, they won in 2018, and this time around, the seats were tied. But the PPP got more votes than them. So in Bartica, which they won the last time, this time around, the seats were tied with the PPP getting more popular votes than them. As a result, we won the mayor and the deputy mayor. Yet, they have won. I don't understand. At Madhya, again, in 2018 they won. This time around, the seats were tied. Again, we got more votes because we were able to get both the chairperson, the mayor, and the deputy mayor. In Georgetown, last election, I believe we got 7 seats. This election, we got 11 seats. Last election, we got 7 seats. This election, we got 11 seats. Yet, they're saying that they won, they got more votes. New Amsterdam, last election, I believe we got 3 seats. This election, I believe we got 6 seats. Our seats increased by 100%. In a number of NDCs that we lost the last time, we were able to tie this time. Maruka, Providence, Region 2, we lost the last time, we tied this time. And because we got more votes using the legal formula, we were able to get the chairman and vice chairman. Industry Plaisance, we lost the last time, we were able to tie this time. We got more votes again, we got the chairman and the vice chairman. Woodlands Bel Air, we were able to tie again, and we got the chairman and the vice chairman. Platanka, Corterabat in Region 6. Again, we were able to tie, having lost in 2018. Gibraltar Firish, we were able to tie, and we got the chairman and vice chairman. In all these tied areas, we ended up with the chairman and the vice chairman, or mayor and deputy mayor, as the case may be, because we got more votes. And when you apply the formula in the law, we ended up with both the chairmanship and the vice chairmanship and the mayor and the deputy mayor. Yet APNU, APNU, celebrating a victory. And Mr. Norton is saying that he got more votes than the PPP at those elections. I don't understand how to rationalize these disclosures that are not made at bottom house meetings, you know. These are not hush-hush whispers in a corner. These are public statements that are being televised and are being streamed live and circulated proudly on the social media, including Facebook. And that's why I am saying either there is a high level of delusion, or people are simply living different alternatives in Guyana, different realities. I don't know if it's a mental issue, I don't know if it's a psychological issue, I'm not trained in that area, but that is my observation. And you go and verify it for yourself. Look at election results, look at the votes accumulated by the two parties and listen to the statements that are being made by AP and UAFC and look at the celebration that they are engaged in, and you come to your own conclusion. Last week, I mentioned on this program that the Guyana Public Service Union has filed legal proceedings challenging the nomination of Mr. Mohandat Gulsaran by an organization called the Senior Staff Association, an organization within the public service. And I said that this organization was formed in 2002, that in 2003, a motion was moved in the National Assembly to recognize this organization as an organization representing public servants of a particular category or class for the purpose of making recommendations or nominations to the National Assembly for the purpose of appointing members of the Public Service Commission. I remarked that for 20 or more odd years that these nominations have been coming, they have not been challenged by anyone, including the Public Service Union. When I say they were not challenged, I meant they were not challenged in the court. The Public Service Union wrote a long epistle accusing me of unprofessional conduct and of disrespecting them, that they have always been opposed of this body. I don't think I said that they never opposed the body. I said they never questioned it in what I meant in a court of law. And that is the truth. They have now questioned it 2 decades after nominations have been made consistently. And when they know full well that the Parliament itself, maybe because of question raised 20 years ago, moved a motion to clear all doubts by saying in that motion that they are recognizing this body as a body representing a class of public servants. Nobody de-recognizing the Guyana Public Service Union. Not at all. The Guyana Public Service Union is always recognized as a representative of public servants. But they are not the exclusive representatives of public servants. And it would appear as though they wish to convey that impression. Not at all. This other organization has also been recognized as a body representing public officers and has been so recognized for the past 2 decades without any legal challenge. And that's all I said on the program last week. And I maintain most resolutely that the action filed by the GPSU is one that is without merit. And it is intended to undermine the Constitutional Commission and to impede it from discharging its constitutional mandate, which is so important to our democratic architecture. I maintain those positions. I don't have a problem with people filing cases. I'm a lawyer. My job is to be in court. That's what I was trained to do. That's why I studied law. But one must be able to know what type of case one is going to file You don't file cases that are manifestly weak, in my view. And I believe from all perspective, that case is a case that is manifestly weak. And I express that view, and that is, I'm entitled to that view. As I am on the issue of litigation, you would have read in the news that Mr. Basil Williams has decided to appeal the $10 million judgment awarded against him in my favor by the High Court recently in a defamation action. You would have heard me say that I would be happy if Mr. Williams appeals, because it will give me an opportunity to cross appeal. And in that cross appeal, I will challenge the quantum of damages awarded, for I feel that $10 million is not adequate, having regard to the gravity of the harm done, and having regard to recent defamation awards made by our courts in assessing compensation or assessing damages. In particular, in defamation cases, judges are guided by awards made in similar circumstances, especially in recent vintage. And if one is to examine the awards made recently, one would conclude that $10 million is an award to the lower end of the spectrum rather than to the upper end of the spectrum. So Basil Williams perhaps heard me and has done me the favor by appealing, and has given me the opportunity to file a cross appeal in which I will appeal the quantum of damages awarded. But what is significant is the grounds upon which Mr. Williams is lodging, the grounds upon which he has lodged his appeal. Among the grounds canvassed, I haven't seen the documents, but I'm going with what has been reported in the newspapers. Mr. Williams is alleging that I used methodologies of artificial intelligence and some type of cloning mechanism to apparently clone him and project on a television screen a person who is not him. And then apparently I would have been able to manipulate this image and to put Basil Williams' voice into this image so that the picture projected on the screen would have appeared to be like him and also sound like him. For the purpose of the record, the press conference at which Mr. Williams spoke and at which he published the libelous remarks about me was done at the NCN, National Telecommunications Network studio. And I managed to secure a copy of the video recording of what he said. And as he was denying it in the court granted me permission under the rules of evidence to show that video on a television screen in the court as part of the evidence of the case. So Mr. Williams saw himself on a big screen TV that are now installed in all the courts and heard himself speak. So now he's denying that it is him in the video. He's denying his own voice, his own image, and he's saying that I cloned him somehow and that I used artificial intelligence mechanisms to fabricate this image and this voice as his, when in fact, according to him, it was not him on that image, in that video. So, we are living in very interesting times. I'll be very excited and as well intrigued to see how Mr. Williams is going to argue this appeal and how he's going to prove to the appeal court that it is not him on that video. I hope that members of the public can join or can come to the court. It would be quite an event, I must say. But that's a matter for the court, and we will leave it there. I was copied in a very interesting letter addressed to the Chancellor of the Judiciary, the Honorable Madam Roxanne George, Chief Justice, the Honorable Mr. Justice Karl Singh, retired Chancellor of the Judiciary, the Honorable Mr. Bisraj Singh Roy, Justice of Appeal, and Mr. Maniram Prasad, Chairman of the Public Service Commission. These are all members of the Judicial Service Commission, and they were written to by a lawyer, Mr. C.V. Satram, who apparently was acting on behalf of Arud Gosai, attorney at law, and Ramon Gaskin, a public commentator. The letter was also addressed to me for the avoidance of any doubt. And this letter calls upon the Judicial Service Commission to adopt a certain methodology as it seeks to recruit new personnel for the lower, middle, and upper judiciary. There are vacancies, no doubt, in the magistracy, in the High Court, and at the Court of Appeal. One of the tasks that the Judicial Service Commission will invariably have to embark upon very shortly is the recruitment of personnel to fill these vacancies. And this letter is calling upon the JSC to adopt a particular process to ensure that the process of recruitment is transparent, is fair, and is accountable. The letter suggests that advertisements should be published inviting suitably qualified applicants. These advertisements should be published in Guyana, the Caribbean, and in the wider Commonwealth. And should be open to the largest pool of persons. The letter makes the important point that in considering the issue of promotion, that the Commission should be careful in their evaluation methods and should take into account judges and judicial officers. Well, take into account the conduct and performance of persons whom are being considered. In particular, if they have been on the bench, to take into account how many decisions they have rendered, how many decisions they have outstanding, because we have an act, a law, which mandates judges to write decisions within a prescribed time. I believe 6 weeks after the case would have concluded, arguments and submissions would have concluded. And this letter is calling for compliance with that legislation. The letter also calls on the Commission to assess candidates on the basis of meritocracy. And the letter states that if these canons of transparency, accountability, and fairness in the recruitment and promotion of judicial personnel, including members of the magistracy, are not adopted by the Judicial Service Commission, the letter indicates that legal proceedings may be instituted to review appointments made which the two persons may consider defective in that they have not complied with what the letter indicates should take place. So, the letter was widely circulated and covered in the press. And while the Judicial Service Commission is an independent constitutional body, it is enjoined, like every other constitutional organ, to act transparently, to act fairly, to act reasonably in its decision-making process. And if it is going to recruit, then it must do so on certain established criteria, including, of course, meritocracy and performance. The government would always encourage transparency and accountability and fairness in every aspect of national life. I have repeatedly said that the judiciary, and I have no doubt that the judiciary can't object to it performing its functions in a transparent and accountable manner within the given parameters of how a judiciary should conduct itself. When the CCJ was here last month, the CCJ spoke candidly about these matters, both internally and publicly. Recently, we had a forum of Caribbean heads of government, and they recognize that there are difficulties in the justice system across the Caribbean, and that some changes, some degree of introspection have to be done, and changes have to be made in order to continue to ensure that the rule of law is maintained and that high standards obtained in the justice system across the region. The government supports any initiative that will bring about those types of changes, and will work with the judiciary. Will work with the judiciary in the attainment of those very important goals and objectives. Today I read in the Guyana Chronicle newspaper an article written by Mr. Freddie Kissoon, in which he laments about inconsistency in sentencing guidelines. And this is a matter of great public concern. Many members of the public, letter writers in the newspapers, public commentators, and lawyers, not to mention victims of crime, have often expressed the view that sentencing patterns in Guyana are not uniform, they are not consistent, and sometimes they can be viewed as erratic and eccentric. When one looks at the empirical data, and Mr. Kissoon cited some in his article, for example, a man and a guard brutally murdered in the man's house in quarantine, and the assailant found guilty and sentenced to 4 years imprisonment, or may have pled guilty, I'm not sure, but the penalty was 4 years. Now one can understand that one can appreciate different circumstances. You can have the circumstances where a fight erupts in a rum shop, which regularly happens in Guyana. Or there is some misunderstanding due to some personal matter, and there is anger, and there is a violent eruption, and death can result. And one can go through the various circumstances. But when a man is killed in his home by bandits, and they kill his guard, those are different circumstances, completely different circumstances. In a society where violent robberies, home invasion, kick down the door banditry are rampant and have caused historical incalculable damage to families, to the psyche of this nation. When a person in those circumstances gets a sentence of a few years, less than 5 years, then it must raise eyebrows. Persons like me ministers of government, members of parliament, public officials, when we do outreaches and we walk the streets of this country and we interact with the ordinary men and women of Guyana, these are the things that they tell you. These are the things that they tell me. Somehow they believe, of course wrongfully so, that I have some say in sentencing and that I can somehow influence these sentencing patterns. I can't. I've repeatedly explained that the judiciary is independent, but that there are certain principles that govern the way sentences are formulated. Well, it has to do with the gravity of the crime, the extent of the cruelty. It has to do with the prevalence of the offense. It has to do with extenuating or aggravating circumstances. It has to do with the age of the victim or the age of the accused person. It may be influenced by the character and reputation of either the deceased or the accused persons. All these are factors that have accumulated over the years and have formed themselves into guidelines that judges ought to adopt in handing out these sentences. But we have what you have in today's paper, for example, where there is a long article critically commenting on sentences. So as a result, the Legal Affairs Ministry has commissioned a project under an IDB loan program, Support for Criminal Justice, a project to craft sentences guidelines for Guyana, examining Guyana, examining similar guidelines promulgated in the Caribbean in particular, and then other jurisdictions, and formulate for Guyana a peculiar and unique set of guidelines for the Guyanese judiciary and the Guyanese legal system that will take into account the realities of Guyana. That project is an ongoing one. Naturally, it involves a consultative engagement or engagements between the practicing bar, the police force, the Director of Public Prosecutions, and the judiciary. I believe that the consultative engagements have concluded, except with the judiciary. Hopefully, that will be done shortly, and we can have those sentencing guidelines available for promulgation. The judiciary is central to this process because it's a judiciary that will have to hand down these sentences. So an input from the judiciary is crucial in this whole process. So we are working on sentencing guidelines. As I read that article today, I thought that I would mention that on this program. I want to congratulate the Guyana Police Force on launching a week of activities to bring greater awareness to the road traffic problem that we have in Guyana. We have a serious problem on our roads. Too many of our people, in particular our young people, are dying or are receiving serious and permanent injuries on the roadways of our country. Our roadways have long been a very hazardous place, and it should not be so. And this is where government can play a role, and government has been playing a role and will continue to play that role. But it has to do largely with users of the road. Pedestrians, cyclists, motorcyclists, electric bikers, minibus, lorries, and all other users of the road. This requires a collective effort. We have, per capita, possibly one of the highest incidents of road fatalities and road accidents in this part of the world. You travel to any country in the Caribbean or even further afield, and you will not see the high volume of road accidents that we witness in this country. Something is wrong. The discourtesy on the road, the arrogance and ignorance, the haste, the anger, the recklessness, the negligence, the carelessness, all combine and result in what we have today. And this transcends every form of road user, from the pedestrian to the motor lorry driver. Nobody is without blame. We will continue to pass laws to strengthen the legal architecture, but a large part of it has to do with the users of the road. The culture, the mentality must change. So recently we passed a menu of statutory measures where we have created the offense of motor manslaughter. We have created a statutory regime to ban people from driving, forfeiting and revoking their driver's license permanently, suspending their driver's license. We have passed a law that imposes obligations and duties on the bar owner or the bar owners not to sell intoxicating liquor to drunk people who are driving, not to sell intoxicating liquor to minors, to call the police if they see a person leaving their premises drunk and going to drive, to put up signs at conspicuous places in the bar prohibiting drivers from drinking if they plan to drive, and to make public announcements in the bar. I don't know whether these laws are being enforced, but I am happy that the police is committing once again to combat road trafficking in a very aggressive way, road traffic offenses in a very aggressive way. We will continue to strengthen the laws, increase the fines, and create heavier penalties. But it requires much more than that. It requires a cultural change. It requires an attitudinal change, and that must come from the people, the users of the road. The Attorney General Chambers and the Guyana Police Force are working together to implement an e-ticketing system which will, using CCTV cameras across the city and across the country, to detect traffic offenses. And once they are detected on that CCTV camera, an electronic traffic ticket will be generated, which will be sent to the owner of the vehicle and must be paid at the relevant magistrate court's office, the same way that manually issued tickets are being paid. Well, the law will now be amended to allow for electronic issuance of ticket based upon images generated by CCTV cameras. In the database, we will have the owners of the vehicle. We may not have who is the driver, but the owner will be ticketed, because the owner will then be responsible to say who the driver is. And that may also cause another charge, because if that person is not authorized to drive, or not licensed to drive, or not permitted by the insurance to drive, that may create another set of offenses. Many other countries in the Caribbean have gone in this direction, and we are moving swiftly there. And we are not doing this because we want to punish people. We are doing this to protect lives, to make the roads safer for all of us and for our future generations. When we pass the e-bike laws, the people are up in arms, as though we have some malice against them, or we are inspired by some spite against them. It is not that. We want a safe public environment. We can't have our people dying on the roads with the alarming rapidity and frequency at which they are dying at this current point in time. And a responsible government must react. So, this e-ticketing will be soon implemented. And that brings me to our legislative agenda. You will recall that we, through our Minister of Trade and Tourism, the Honorable Unesh Waldron, the first reading of the Electronic Communication and Transaction Bill was done a few sittings of the Parliament ago, and on the next sitting of Parliament, scheduled to take place on the 3rd of August, that, among a large number of other bills, will be debated and hopefully passed. That particular bill, the Electronic Communication and Transaction Bill, is the bill that will allow for electronic transactions and electronic payments to be done in the central government and public sector architecture. The purpose of the bill, in short, is to allow for payments to be made electronically in the state agencies, in the government departments, and in the government ministries, where payments are now made only manually. This bill will create the requisite legal environment that will allow for the technological platforms to be established, installed, and operationalized across the public sector, so that you can now have electronic signatures instead of manual signatures. And you can pay now with your credit card, and you can pay by any other digital mechanism or digital medium in places where currently only cash and payment manually are now permissible. That will change completely and fully going into the future. This is another transformative initiative, along with the whole line of others that we are pursuing in the government as we continue to work to modernize the public sector, modernize government, and modernize Guyana. And that is why, we have to continue to explain these important, innovative statutory changes that are taking place. And government has recognized that. We are making these monumental changes, formidable changes, commendable changes that can have transformative effect, but we are not talking about it. So right now, we have a consultancy out by the Ministry of Legal Affairs, where we are advertising for a form of public relations personnel to be hired to put in a bid to offer public awareness program, in particular in the legal sector, because we need to explain to the people of our country the laws. If you don't understand the laws, then how will you be able to comply with them? The laws are passed for you, for the people's benefit. And they must not only understand the innovative nature, the improvements that the law will bring, and how the law will impact their lives, but they must know what the laws are, or else they will never be able to obey the law and comply with the law. So I am hoping that suitably qualified persons will put in their bids and compete to offer this important service to our government as we continue with our legislative agenda. My operator is signaling to me that we have come to program time now. The time has run out so quickly. I want to thank you very much for spending the past hour with me. I believe that we have covered a whole gamut of important issues. I want to thank you very much for spending the last hour with me. And until we meet again next week, Tuesday, please stay safe and enjoy the rest of your night. Good night. Thank you very much, and I see you next week. Thank you.